Go ahead and start with Module 1, where we'll address common law. So as a newcomer to environmental law, you'll naturally ask, where does environmental law come from? I don't want to belabor the point, so let me just say that it comes from a hodgepodge of constitutional authority, statutes, regulations, international norms, but in the early days of our country, it came from the common law. Common law refers to the precedents set by courts. When a court decides something, that decision enters the canon of common law. It gives us order by knowing what to expect with a given set of facts. In short, common law provides us with a core principle on which to understand environmental law. At its core, environmental law is about efforts to harmonize conflict between human activity and our interest in the physical world. In the early days when these were in conflict, we called it a nuisance. Under nuisance law, courts work to protect against invasion of interest in the use and enjoyment of land. Think about living near a pig farm. The odors become a nuisance and prevent you from enjoying your home. Under nuisance law, the objective was clear. If the interest had been invaded, then a nuisance was found and the offending actor told to stop. Around the time of the Industrial Revolution, things began to change. In addition to looking at the interest that had been invaded, courts began to look at the utility of the offending action. Keep in mind, in the early 1900s, our country was beginning to grow at a fast pace, and this economic engine was driving prosperity. In sum, courts began to balance the person's enjoyment interest with the utility of the offending action. This would, many years later, be referred to as a cost-benefit analysis, a foundational principle in environmental law. Let's pause here and have you read our first case, Boomer versus Atlantic Cement Company. If you'd like, I've attached an article here as well on how to read a legal opinion.